There was no data breach, no leaked password, no hacked server. Yet millions of confidential documents, shielded for years by wealth, lawyers, and the justice system, finally surfaced. Not through illegal leaks, but through a masterstroke of understanding the law itself. This is the ultimate hack you've never considered, one that bypassed computers to dismantle the system from within. On July 8, 2019, a private jet touched down in New Jersey. Federal agents escorted a man off the plane. Not a politician, not a tech mogul, not a cyber criminal, but Jeffrey Epstein, whose name would soon unleash a torrent of records rivaling history's biggest exposés. Within weeks, he was dead. No trial, no testimony, no verdict. The criminal case vanished abruptly. But the documents, they lingered in the shadows of the legal machine. Witness statements archived, depositions sealed, financial trails buried under non-disclosure agreements and jurisdictional walls. Everything preserved, just invisible. Epstein's first major encounter with the justice system happened in 2008. The case ended not with a courtroom battle, but with a negotiated agreement. The outcome avoided a federal trial and limited exposure. At the time, the public saw closure. But behind the scenes, the real story was just beginning. Because legal agreements don't erase records, they reorganize them. Witness statements were archived, depositions were sealed. Financial trails were documented, then restricted. Everything was preserved, just not visible. This is the part most people misunderstand. When a case ends, it doesn't vanish. It becomes inaccessible. And inaccessible information is often more powerful than missing information. In cybersecurity, you can hide data using encryption. In law, you hide it using process. Non-disclosure agreements, confidential settlements, sealed discovery, jurisdictional overlaps between state and federal systems. Each tool is legal. Each has a legitimate purpose. But combined, they can lock information away for decades. Survivors were redirected into civil courts instead of criminal ones. Records were produced for attorneys, not the public. Evidence existed, but only inside controlled environments. This wasn't a cover-up in the movie sense. It was something quieter. A system doing exactly what it was designed to do: control access. In 2019, when Epstein was arrested again on federal charges, public expectations skyrocketed. People assumed answers were coming. Instead, the case stopped entirely. No testimony meant no new evidence introduced into public record. No verdict meant no final narrative. But the documents already created, they didn't vanish. And that's where the real breach began. Years after the criminal case ended, a slow, technical process started unfolding. Civil lawsuits continued. Judges reviewed sealed records. Lawyers argued over public interest versus privacy. And one by one, seals were lifted. Not dramatically, not all at once. Quietly, depositions that had been hidden for years were ordered released. Court filings once accessible only to attorneys became public. Supporting exhibits followed. There was no leak, no insider, no illegal access. Just procedure, used persistently. This is why some journalists later referred to it as a legal hack. Because nothing was broken. Everything was accessed exactly as the system allowed, if you knew how long to wait. When the releases began, people expected a single revelation. What they got instead was volume. Millions of pages, flight logs, calendars, contact lists, financial summaries, interview notes, depositions taken under oath. This collection became known as the Epstein Files, but calling them files creates a false impression. They weren't one archive. They weren't organized. They weren't designed to tell a story. They were fragments, and fragments are dangerous because they invite assumption. As documents surfaced, names appeared. Some were central to legal proceedings. Some were peripheral. Some appeared only once. Here's where context matters. A name in a document is not an accusation. An accusation is not evidence, and evidence is not a verdict. Flight logs, for example, showed who traveled, not why or what occurred. Contact lists showed connections, not intent. Calendars showed meetings, not actions. But online, nuance vanished. Documents meant to be read slowly were turned into lists. Lists were turned into conclusions. The same files used by journalists to investigate responsibly were used by others to speculate. And the files themselves couldn't correct anyone. Because documents don't speak. People speak for them. Despite confusion, some elements were consistent across records. Investigative materials and sworn testimony documented repeated exploitation of underage individuals by Epstein. That fact was not ambiguous. What was ambiguous was the extent of others' involvement. There was no master list, no central ledger, no definitive hierarchy, just overlapping timelines and incomplete trails. This wasn't a failure of transparency. It was a limitation of documentation. Because documents can only record what was captured, not what never reached a courtroom. When more records were released, new problems emerged. Some documents were heavily redacted, nearly unreadable. Others were released with errors, exposing private information that shouldn't have been public. Victims' privacy clashed with public interest. Accuracy clashed with speed. Even transparency became controversial. Who decides what should be released? How much context is required? And what happens when information is technically public but practically misleading? The Epstein Files didn't answer those questions. They exposed them. The internet wanted a final reveal, a moment where everything aligned, a single document that explained everything. It never came, because reality doesn't work that way. There was no closing scene, no unified explanation, just an understanding that systems can delay accountability without formally denying it. And that delay can last longer than public attention. In response to public pressure, lawmakers increased oversight. Federal agencies were instructed to review related records. Members of Congress accessed unredacted materials in secure settings. But even then, expectations outpaced reality. Oversight doesn't create new evidence, it only evaluates what exists. And much of what people wanted to know had never entered official record in the first place. This is not a story about secrets being stolen. It's about secrets being stored. It's about how power interacts with process, how legality can create distance, how information can exist without being accessible. The Epstein Files didn't expose everything. They exposed how much depends on what never gets documented. They show that justice doesn't always fail loudly. Sometimes it stalls quietly. It's tempting to see the Epstein Files as a one-off event, something tied to a single name, a single network, a single moment in time. But that interpretation misses the larger pattern. Because the mechanisms that delayed access to these records are not unique. They exist everywhere. In corporate disputes, in political investigations, in financial collapses, in institutional misconduct cases. Sealed documents are routine. Confidential settlements are common. Non-disclosure agreements are standard. Most of the time, they function exactly as intended, to protect privacy, prevent harassment, and keep legal processes fair. But when those same mechanisms intersect with wealth, influence, and time, they can quietly reshape public understanding. Not by altering facts, but by delaying them. And delay changes everything. Witness memories fade, paper trails thin out, public attention moves on. By the time information surfaces, the environment that once gave it meaning may no longer exist. That's why the Epstein Files became so significant in the digital age. Not because they revealed something entirely new, but because they showed how much information can exist without ever becoming part of the public conversation. In a world obsessed with leaks and hacks, this case demonstrated a different reality. You don't always need to break into a system to expose it. Sometimes you only need to understand how it works and wait. The legal process, slow as it is, eventually creates openings. And when those openings appear, what comes through isn't always clarity. Sometimes it's complexity, sometimes it's contradiction, and sometimes it's the realization that no amount of documentation can fully reconstruct moments that were never examined under oath. That understanding, uncomfortable as it may be, is part of what makes the Epstein Files more than a headline. They are a case study in how modern systems remember, forget, and reveal. In hacking, the most dangerous vulnerabilities aren't the obvious ones. They're the ones everyone knows about, but accepts. The Epstein Files aren't disturbing because of what they reveal. They're disturbing because of what they don't. No testimony that was never given. No questions that were never asked. No answers that were never recorded. And no document can replace that. The legal hack that exposed this empire didn't break the system. It used it. And in doing so, it revealed something far bigger than one individual. It revealed how information can be controlled, not by secrecy, but by access. Because sometimes the most powerful firewall in the world is a locked filing cabinet labeled sealed. And sometimes the most effective breach is patience.